Hey guys, what is up? It's Dusty here, and welcome back to another crypto video. And today, we have a really interesting video on the SEC v. Ripple. It's a really interesting thread. So if you enjoy the lawsuit updates and the lawsuit talk about Ripple/XRP and the SEC, make sure you press that like button. And of course, if you aren't yet, it is worth it to subscribe to the channel. Like half, if not more of you guys watching right now are not subscribed that you watch a lot of these videos. Make sure you press that button, be done with it. It is easy and simple. Okay, so a partial historical review of the SEC v. Ripple. Well, before we get into any of that, we have to quickly read this tweet by Mac Attack. It's about a document here, or I should call it a article. SEC threatens court with consequences if they lose Ripple lawsuit. That, ladies and gentlemen, is very interesting. And Mac says, SEC threatens court with far-reaching consequences if they lose the Ripple lawsuit. The US SEC believes that the wrong decision in the case against Ripple could set a dangerous precedent for the regulators. You know how big this is? You know how significant this article? You know what? Let me even now, live for you guys, tweet it out real quick. Let me tweet it out because of how significant this one is. I am literally bamboozled by the significance of this article. So to give you guys a little rundown, what the SEC has basically done is they have now claimed that if they were to lose this, all the other crypto companies could also use this Ripple case as their back-in, and that might make it so the SEC cannot win lawsuits in the crypto space anymore. That's basically what it comes down to. It's really interesting. It's really interesting. So there's an entire thread here made by John Deaton as kind of a review of what's been going on. A partial historical review of SEC v. Ripple. The SEC waited 8 years to bring a case against Ripple, allowing individual investors to buy XRP on over 200 exchanges worldwide. By the way, this exchanges worldwide is a key factor because every single person ever buying XRP as a non-US citizen outside the US, they're fine. They're, by the way, not under SEC jurisdiction, but they kind of forgot that for a little second. In 2015, the Department of Justice and FinCEN declared XRP a convertible virtual currency. In 2017, when the SEC aggressively sued companies in the digital asset space, violating security laws, it left Ripple and XRP alone. If you're wondering why, it was actually in 2017 they went on a really massive ICO campaign. They made a clear rulebook for ICOs, and they made it so that every project with an ICO was ticked on the fingers a little bit, except for Ethereum, kind of. It's not an official ICO, but then again, it kind of is. Now, that's again why they left XRP alone, because they did not have a crowdfund or ICO. In 2018, the SEC allowed Ripple to purchase a 9% stake in MoneyGram, fully knowing XRP would be transferred to MoneyGram, who would in turn immediately sell it in the secondary market on exchanges like Coinbase to individual investors with no connection to or even knowledge of the company Ripple. After more than a 2-year investigation, 2.5 years, into Ripple and its executives, the SEC could not find one instance of fraud or misrepresentation. Hence, the founder of Ripple and the CEO and whatnot were not sued for fraud. Because if the SEC could, they would have done that. Right now, this is the first case that we can actually cite where the CEO and founder of a crypto project have actually been sued together with the project as well. It's the first time. And people are wondering why, if it's not even fraud. Now, in 2018, Hinman gratuitously declared Ethereum not a security while collecting over $15 million from his law firm, a member of the Ethereum Alliance. In October 2020, 2 months before Clayton had left the SEC, One River Asset Management, which is again connected to Jay Clayton, invests $1 billion into Bitcoin and Ethereum. 2 weeks before filing the case, former SEC Commissioner Grundfest warned Clayton not to file this lawsuit because there was no exigency and investors would lose billions. Grundfest informed Clayton that the SEC had made no material distinction between Ethereum and XRP, and if he filed the case, it would call into question the SEC's motive and discretion. Despite this grave warning, and a new administration coming into power in less than 30 days, Clayton directed a suit against Ripple and XRP on his last full day at the SEC. Less than 3 months later, Clayton accepts a job with One River as an advisor on its Bitcoin and Ethereum investments. For the first time in history, and directly against precedents such as the Telegram case, the SEC claims the digital token XRP itself is a security. The lawsuit caused $15 billion in losses to XRP holders, despite claiming that the executives at Ripple enriched themselves selling unregistered securities to the present day. The SEC allows the co-founder Jed McCaleb to sell billions of XRP before and after the lawsuit was filed against Ripple. The SEC has yet to produce court-ordered relevant discovery related to Bitcoin, Ether, and XRP, and Judge Netburn has ruled the discovery is both relevant and necessary, not just related to the fair notice defense, but also for the court's analysis of the Howey factors relevant to XRP. The SEC objects to XRP holders being heard in the lawsuit, even though it claims it brought the lawsuit on behalf of those investors. And the most interesting part there is that what they're saying is that the XRP holders, spearheaded by John Deaton, cannot enter into this lawsuit because they are properly represented, right? That's one of their main points. By who, though, you might ask? They're saying that the XRP holders, aka just the investors the SEC is sworn to protect, are protected or fallen together under Ripple, which is a really big joke. Instead of addressing the arguments made regarding the independent utility of XRP, the SEC attacked the lawyer representing XRP holders, who is John Deaton himself, claiming he is biased and unfair to the SEC. After losing several discovery disputes, the SEC warns the court that if it loses the case, which is again what the article right now is about, right here, this article. If it loses the case, it will, the SEC warns that the court, that if it loses the case, it'll cause irreparable damage to the SEC related to future enforcement actions in the cryptocurrency space, and the court should consider such consequences before ruling. Now, if I hear it like that, it's like, ooh, okay, the SEC is afraid they're going to lose this one. Otherwise, why would you claim that type of stuff, right? And of course, on a second basis, I would say, well, if you bring that to the table, it kind of means you're at your last resort, and you're already thinking that this case specifically is relevant to others, which of course is the case. Then again, shouldn't that be a reason why you shouldn't just sue Ripple like that? I mean, what? I guess what I'm feeling right now is that they are afraid to lose, not necessarily afraid that they made a mistake, but just afraid to lose altogether instead of, maybe they just come to a settlement. It will not be just such a problem if they can make it out to be a win. But if they fully lose in summary judgment, I don't think they're going to like that. Maybe that's kind of what I fetched from that they're just afraid that they're going to lose. That's why they put it up. I won't make any editorial comments. Our motion to intervene is pending. For the record, all I've done here is provide a true and accurate review of some of the factual history thus far. I'm not being biased or unfair. History speaks for itself, and you can make your own conclusions, which I decided to put some extra commentary there. However, the rest is definitely unbiased and put up fairly because these are actual events and actual statements and whatnot. This really happened. It's all rather interesting because a lot of us, including once more me, are just wondering why exactly the SEC brought this action. And for example, there's two things which I'm mainly wondering about. Why did they, for their MOU usage, which basically meant that they could contact foreign regulators through a process which only a government agency could do, they could have done this before filing the case. They didn't do that though. They filed it in discovery motion, the discovery period, which is unusual because usually you have a level playing field. Then again, they had the power, and Ripple said, don't use it because we want a level playing field. We want to be fair with all of this. The SEC said, no, we want to rule this out as quickly as possible. The judge sided with the SEC because, again, it's efficient and they could request it anyway, so why delay this process? That's kind of a too long didn't read version. It's a summary. There's a couple points left out. Now, a little bit later, though, the SEC filed for an extension of discovery, which is kind of contradictory. The Ripple side said, hey, we want it to be fair. Even though it's going to take longer, we want it to be fair. The SEC said, no, we don't want to extend this any longer because you and us both have a benefit for this all going quickly. They literally stated that we don't want to extend this discovery any longer than it needs to be. And then, bada boom, bada bing, they want to extend it for 60 days. Then another point here is how fast the judge has been putting up these documents, even over Memorial Day weekend, and they still want to extend. That type of stuff is so weird. Of course, I can also ask y'all and myself, just like, why would the SEC sue them in general? But I'm not going to get an answer to that one. I don't think ever. all we can do for right now is spread this word to as many people as possible. Get people wondering what exactly is going on here. And hopefully there's going to be some end to this entire freaking debacle of BS. Because that's literally what I'm about to call it here. B-freaking-S. It is so stupid. Now, Arturo Portilla said, yet the whole U.S. crypto industry chooses to act as if the case was only relevant to defendants, so only to Ripple. The SEC itself is now acknowledging how an unfavorable verdict could harm their oversight across the industry. What else do we need to understand the relevance of this case? So what Arturo is kind of pointing towards here is that everybody was just saying that, oh, this case only matters for Ripple, yada, yada, yada. They were not really viewing it too much. I'm talking about the people outside the XP community. I often was an advocate of saying, no, this case is important for every crypto company out there, regardless of whether Ripple wins or loses. If they lose, it's going to be really important because, well, those same defenses that other crypto companies are going to be using will be denied on the same reason because of this case precedent. And the same thing, if Ripple wins, other cases will be using this too. It'll be harder for them to lose. Now, Arturo is now pointing out that the SEC themselves are also showing this now. The court should avoid setting precedents with such far-reaching consequences, SEC officials said. According to the regulator, in the event of a loss, future defendants will be able to refer to the decision in the Ripple case. Yes, please. It's interesting. And again, John Deaton then again said the court should follow the law by John E. Deaton on behalf of XP holders. In the end, guys, I hope that the court will just figure itself out and straighten this all out, but we shall see. We shall see. A couple other things I had was just the manipulation in the crypto market, man. The amount of FUD right now is just insane, if you're wondering. Concordium aims to end the era of anonymity in the crypto industry. Crypto and blockchain industries needs to play by the rules of the realize their full potential, Concordium CEO says, and that's again about the anonymity of Bitcoin. Then we have this one, which is that the US basically has cracked Bitcoin. A lot of people were speculating about earlier. I still call BS, but all right. And Trump being negative towards Bitcoin or calling it a scam. Those are just a couple of things which came out the last like 48 hours or so. It's just a little bit of stuff, but there's so much FUD right now. There's also obviously Elon Musk, who's been going, I just almost swallowed a hair, going rampant on Bitcoin right now, and there's so much going on, man. It's a complete freaking shit show, if I may say so myself. It's been a really interesting situation, but whatever, man. We are enjoying it the way it is. We'll see where it gets to in time. What a strange situation, guys. But yeah. All right, that was it for today's video. Hopefully you all enjoyed it. If you did, make sure you press the like button and subscribe to the channel. And I'll see you guys again in another crypto video later today or tomorrow maybe.